And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed.
I have no problem with your submission, Counsel, but what I'm saying, he advises the court on law matters which we are going to raise. I have finished the ruling, let him advise, and then you will be given time if it is allowed. I don't know what you are laughing, and I don't understand what it means, because
I think, sir, if he has any points to raise on the matters of law, the procedure is that you can urge out your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires a reference to the Constitutional Court or not. So you can proceed.
Excuse me, I wanted just to know, why are you laughing? Hold on. Unless you don't know his role, maybe he has advised. That's what I wanted. I think the council can proceed. I think, go ahead.
Thank you, Honorable Chair. Honorable members, following the ruling that has just been delivered, our instructions are to seek for a reference on a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional Court. But Mr. Chairman, I want to preface my application for a reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPDF. And it spells out a number of very good attributes for the UPDF: patriotic, professional, disciplined, and so on. Those attributes, in fact, distinguish the UPDF from other previous forces of a similar nature that we have. So they are quite impressionable, they are quite useful. We think that they are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority. Established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to civilian authority. And in fact, the courts, I will be referring you to a number of cases, the courts have made pronouncements to that effect. And we contend that in the finding that you have jurisdiction in this matter, the General Court Martial is putting itself above civilian authority. And I will explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong with this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. And in saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us a chapter 4, which covers many articles on human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of all persons, including accused persons, are inherent. So they are not granted by anybody, not any organ, not any person. They are inherent. And they can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28 on the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as, that Article 28, as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation that brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or disapply or fail to observe that specific article. And one of the most important aspects of that article is in Article 28:12. Article 28:12 provides that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed by law. The emphasis is on the defined. It is what we are dealing with. So Article 28:12 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 28:12. Mr. Chairman, the charge sheet has an offense which is described as offenses related to security. It is contrary to section 128, 1F of the UPDF Act. Perhaps let me read it out. Paragraph F is to the effect that if you do or omit to do anything with intent to prejudice the security of the defense forces, you commit an offense. If you do or omit to do anything. So you could walk into, as a civilian, I could walk into a military barracks. I could be charged with that offense. I could be charged with that offense. If I am a cook and I decide that the porridge I have been asked to make for this morning has, in my assessment, issues, and I refuse to make the porridge, and as a result people go out in a unit and they are hungry and they are ambushed and they have no energy to fight, I can be charged with that offense and I can be put to death. That is if I refuse. If I don't refuse and I make the same porridge, knowing that the portion may have an issue, but we have to eat, people have to go out, it's urgent, and people go out and they develop running stomachs, I can be charged with that offense and put to death. If you do anything, if you omit to do anything. Now, Mr. Chairman, it would be useful if the court looked, while it is considering this application, looked at the rest of the paragraphs, 128(1)(a) to E, because they are very specific as to what it is a person could do. Disclosing by word of mouth or a document information to the enemy, that is clear. Discussing confidential information is clear. Giving a password to somebody who is not authorized, that's clear. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend that the offense is not defined. Article 2812 deals with the gist of it. The purpose for it is to ensure there is no vagueness. So it is the constitutional standard to deal with vagueness. And why is there a problem with vagueness? Is simply because you can have overreach. The application of the section depends on the whims of a person who decides that it applies or doesn't apply. The gentleman making porridge, the gentleman refusing to make porridge. If I disarmed somebody who is perhaps drunk and I assume that he is becoming a danger, and it is 6 p.m. and I have nowhere to take the weapon that I have taken from him, I maybe have to hold it up in the air shouting, that, I have just disarmed this person, I'm not committing an offense. There's a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that offense is written in words that clearly show that the people who drafted it had run out of the clarity. Then they just said, let's just also put a net and see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mokene, we get worms, we get stones, it's okay. Let's just catch everything. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128 1F. And the question that I will pose to the court is simply this: whether that section 128 1F of the UPDF Act is defined in terms of, and therefore consistent with, Article 28(12) of the Constitution. Honorable Chairman, the General Court Martial cannot answer that question because, as I said earlier, the role of answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial, as part of the UPDF, the law-abiding citizen institution, which is why I referred to the attributes of the force, which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution, will find this question one that can be referred for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here severally, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. Mr. Chairman, again, Article 28, Sub-Article 1, spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy, public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Biarugaba is one such case. 2015, Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General and Joseph Tumushabe, 2005. Michael Kabaziguruka, 2016. they have all said the same thing. And that thing is that with the setup that exists in the structure of this court, it is impossible for there to be a fair hearing. They have addressed questions of independence. They have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can and all the respect I can, but taking you back to the attributes of the force being subordinate to civilian authority. If the judiciary has said this is the position, then the force and its organs must subordinate themselves to that position. Because to do otherwise, Mr. Chairman, is to say that the force, that its organs, that the officers and men, the wonderful officers and men that constitute that force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words of the preamble that I spoke about are useless. We head right back into tyranny. You must distinguish yourselves from those forces that did not abide by the Constitution. Mr. Chairman, in light of those decisions, the ones I have cited, and I know my land friends will say one of them had a stay. It is true, it has a stay. It is a stay on implementation, not on interpretation. And when you read Captain Amon Yarugaba, the court there was very clear. Until the apex court has pronounced itself on the interrelated issues, this is a paragraph dealing with Kabaziguruka. Michael Kabaziguruka and Attorney General, as well as ULS and Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is, as interpreted by the Constitutional Court, that we can't be here to deal with civilians. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what those decisions say, until there is a contrary decision. There is the stay, and I'm sure my land friend will refer to it, the stay does not remove the interpretation. And the importance of the Constitution, I don't know what words I can use to express how important it is to abide by the Constitution. Mr. Chairman, the question I would like to frame, I am proposing be framed, is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court-martial, the conduct of the General Court-Martial as an organ of the UPDF to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority. 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody until there is a contrary position. Michael Kabaziguruka was decided about 4 or 5 years ago. There has not been a contrary position. I would pray, Mr. Chairman, that that question also be allowed. We had proceedings, I'm still in Article 28, 1, on the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial the tribunal, an organ of the defense forces which investigates an offense, charges the accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character of the fine officers and men who constitute the court. It has nothing to do with their individual, it's the institution. How can you be a judge in your own cause? How else can you find prejudice other than being a judge in your own cause? The charge sheet tells us about offenses relating to the defense forces. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had an engagement, we've had these engagements with the judge advocate, my good friend, but from this side and that side we're always having contestations. But just for purposes of impartiality, the panel, and also yesterday we went through what the panel consists of, but we found a regulation. This is just an example. Regulation 69. So yesterday we had an issue around the judge advocate and whether his views are binding or not, the advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69(2) says that a court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on a point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked on who the convening authority is. It's the High Command. Now, if a court will adjourn or can adjourn or is empowered to adjourn or is allowed to adjourn to consult the High Command, Mr. Chairman, Article 28(1) would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances where we are, where the defense forces are the complainant, the investigator, the witnesses, the judge, is a trial before the court-martial consistent with Article 28(1)? Is it? Can it be? We submit. That question needs to go. There are other factors dealing with impartiality. They have to do with the tenure, security of tenure, and so on. So in the other civilian side where we are maybe a little bit more familiar, we know that there is sanctity there. There are provisions that protect, that reinforce, they protect the judicial officer. So we have a challenge. Going back to the judge, if the court is bound by the advice of the judge, who is not a member of the panel, who is making this decision? And I say this, I have said again, I will emphasize, it has nothing to do with the character of the individual. It has something to do with the structure of the law. If indeed my learned friend's advice is binding, why is there a panel at all? So, Mr. Chairman, I want to pose a question. And the judge advocate's power is in Regulation 63(2). Whether Regulation 63(2) and 69(2) of the UPDF Rules of Procedure Regulations are consistent with Article 28(1) of the Constitution. Honorable Chair, Article 137 of our Constitution deals with the interpretation aspects, and the interpretation of the Constitution can be done in two ways, one by way of petition, the other way by way of reference. Even the one of reference has two limbs, one where the court itself considers it necessary. If in its opinion there is a substantial question of law. But the second one is where a party to the proceedings requests for a reference. The word used is that the court shall refer. If any party to the proceedings requests, the court shall refer the question to the Constitutional Court for a decision. And when that reference is made, the case will be disposed of in accordance with what the Constitutional Court has guided. Mr. Chairman, a fourth question arises. Perhaps this morning also. And it has to do with Section 208 and Article 79(1) and 129(1) of the Constitution. And we want to ask the question whether that Section 208 is contrary to and convenes Article 79. 1. Parliament makes laws for Uganda. For the governance of Uganda. Parliament doesn't have power to set itself outside, even 1 centimeter outside the boundaries of Uganda. We contend. 129.1 has to do with judicial power being of Uganda. So, in our view, Mr. Chairman, there is a question that we want to be interpreted. The place of Section 208 and Parliament. Honorable Chair, the framers of the Constitution, who incidentally also include one of the accused persons, envisage that at one point, as life goes on, there may arise a contestation between individuals and the state and organs of the state. That is what this 137 is all about. So, Honorable Chair, as I end, and my colleagues will supplement on other questions, but as I end, it is our contention that there are very serious questions that have arisen, which on the face of it, and this is the only requirement from the authorities, on the face of it require interpretation of the Constitution. They are not before a field court martial because that is the only time, that is the only court where you can't make a reference. For all other courts, you are allowed to make a reference. A party is empowered to make the request, and when they do so, the court shall refer the question. I pray that the 4 questions that I have posed be accepted and the reference be made on those and any others that my colleagues may add. Mr. Chairman, before I sit down, I also want to draw the attention of the court to another law, the Human Rights Enforcement Act. The Human Rights Enforcement Act is now Cap 12. In Section 11, the consequences of derogating from non-derogable rights of a person are spelled out. Those who do so commit offenses. That's the first consequence. And as far as that consequence is concerned, the offense, even 10 years later, the person who committed it can be charged and is liable to sentencing up to 15 years. Brought to the attention of the court, that's the second consequence. The court is required to declare the trial a nullity. It's a heavy burden. It is a serious issue. So if we try civilians, contrary to Article 28, a non-derogable right, in the face of decisions of civilian courts to which we are subordinate, we are committing offenses. In fact, the court is required to declare that trial nullity, acquit, and discharge the accused person. The defense forces are capable of abiding by the Constitution and the Human Rights Enforcement Act. This court, I am sure, is capable of abiding by the Constitution and the Human Rights Enforcement Act. And I invite it to do so with utmost respect. Mr. Chairman, I'll invite my other colleagues to supplement, but that is our prayer this morning.